Good morning. Please be seated. This is case number C-2008-5016. Beth Ford, in her official capacity as Pima County Treasurer, as the plaintiff, Democratic Party, and others as defendants. And please announce your appearance.
Ronna Fickbaum on behalf of Pima County. I'm sitting at the plaintiff's table today primarily because Pima County was the first moving party in connection with the motions you're about to hear. Present and with me is John Moffett, who's with the county's Office of Strategic Technology Planning.
And, Your Honor, Ralph Ellenwood is not present yet. David Eichner is the former chairman, now treasurer of the Pima County Libertarian Party. Mr. Ellenwood had a sentencing at 9:30 in federal court. He was hoping to be here by 10 o'clock.
And we did delay starting a little bit. I did get that message from you and Mr. Risner, but unfortunately we had to put this off anyway.
Yes, Your Honor. So Mr. Risner is authorized to argue on our behalf while Mr. Ellenwood is not present.
All right, thank you.
Yes, Judge Bill Risner for the defendant Democratic Party of Pima County. Here representing the party is our chairman, Jeffrey Rogers.
Judge Thomas Benavides on behalf of the Regional Transportation Authority.
Good morning, Judge. Sean Vercliffe of the Pima County Republican Party.
John Richardson on behalf of the plaintiff, Beth Ford. Ms. Ford is with me here in court.
All right. And this is the time set for the motion to dismiss the second amended cross-claim filed by Pima County. I want to make sure that I have all of the pleadings, because some pleadings were delivered this morning, which I have not looked at, and some of those were apparently delivered to Judge Cornelio's chambers, because it was his bailiff that brought them over to me just before. I haven't had a chance to look at them. But this is what I have looked at. I have looked at the motion to dismiss itself, filed by Pima County. I've also looked at plaintiff's counter-defendant's partial joinder in Pima County's motion to dismiss the second amended cross-claim, which was filed by Mr. Richardson on behalf of Beth Ford as Pima County Treasurer. I've also read the Democratic Party of Pima Counties and the Pima County Committee of the Arizona Libertarian Party's incorporated joint opposition to various motions to dismiss. I have read the plaintiff's counter-defendant's reply in support of joinder, etc., filed by on behalf of Ms. Ford, and the joinder in the reply submitted by Beth Ford, which was submitted by Pima County. Did anybody else file anything that I either do not have or for whatever reason? Let's see.
Judge, there's also the Republican Party's motion for judgment on pleadings.
Yeah, I saw that, and I'm not sure that we have that scheduled today.
I believe we set it all for the same hearing date, but we'll end up.
Is everybody ready to argue that? I have not read those briefs, but if everybody's ready to argue that, I'll certainly permit that to go forward. Is there anybody who's not? It was your motion for judgment on the pleading?
Yes, Judge. Which is fully briefed.
Are you ready to?
Fine with me, Your Honor. Judge, the RTA didn't anticipate arguing that motion today.
No.
I'm not sure that we couldn't, but I'm just saying.
Did you file?
We didn't expect. We did file a response and a motion to strike.
I don't have it on the calendar for today, so if there's an objection, and if somebody in your position is not prepared to argue it, I'm going to sustain that objection. But if you're ready to go, if you feel comfortable, we'll go forward.
No, we'd object to moving forward.
Okay, all right. And we'll have to set that for another meeting.
Yeah, Judge, the Democratic Party filed a supplemental citation of authorities.
Okay. I'll vote for that.
When was that?
Dated January 6th.
Right. All right, Ms. Fickbaum, this is your motion, so you may proceed.
Thank you, Your Honor. First, just a couple of procedural matters. I am in receipt of Mr. Risner's supplemental citation of authorities, which for the most part cites to Arizona constitutional provisions. I don't know if the court's going to consider those. If it is, I would like the chance to respond in writing. No one sought leave to file anything supplemental, and my understanding of the limited permissive scope of supplemental submissions is if a person becomes aware of authorities they couldn't have known about at the time that they submitted their original response. And since the Constitution's been around since about 1912, that probably doesn't apply. And I don't know that there's anything else in there that's brand new. And so I don't intend to address that today.
Right. What I'll do is, I have not read that. I will take note of the fact that you've objected to that. If I sustain the objection, I'll sustain the objection. If I overrule the objection, I'll permit you time to respond to that in writing. Any objection to that, Mr. Risner, that procedure?
No, Judge. I do object to her characterization of...
And I'll let you respond to that.
Your Honor, the limited issue that I'm optimistic we'll all be able to stick to today is whether or not the second amended cross-claim submitted by the Democratic Party of Pima County, which I'll refer to just as the Democratic Party, and the Libertarian Party of Pima County should be dismissed. I just want to be clear with everyone because I think there's been a lot of misconceptions floated, especially in the media, about what we've been doing in this courtroom. Beth Ford filed a simple declaratory judgment complaint with the court saying, I have these election materials which by statute are subject to be destroyed. Certain important people, political parties, members of the Board of Supervisors have asked me to not destroy those, but the law says I should. So Judge, you tell me what should be done with these records. That was an appropriate request for her to make, and no one today is going to argue that her complaint should be dismissed and you should not make that determination. That determination is left for another day. Also, what I want to make a record on right now is that no one that I'm aware of, and certainly not Pima County, is saying that if the Attorney General's office determines that there was a violation of Arizona's election law as codified in Title 16 or elsewhere, that violation should not be remedied. No one is saying that. And also, no one is saying that the various political parties that have taken an interest in this matter, including the Republican Party, the Democratic Party, the Libertarian Party, do not serve an important or even essential role in monitoring elections. But that also is not what we're here about today. What we are here about today is whether the Democratic Party and the Libertarian Party, through their second amended cross-claim, can expand what is really a very simple lawsuit into something much larger for which there appears to be no basis in law. Their second amended counterclaim proposes that because they are political parties, they have not just the duty, but the right as a matter of law to receive those ballots, to examine them, and then to come to the court and put on their evidence and have the court make a determination that criminal conduct occurred if that's what they believe occurred. And then they also have the right and the duty to work with the court to fashion a remedy for that criminal conduct, if in fact the court determines there was any ballot tampering that occurred in connection with the May 2006 special election. That is beyond this court's jurisdiction, and that fails to state a claim upon which relief can be granted. Number one, even though the Democratic Party says in its response, no, we're not looking to mount an election challenge, this would be an election challenge. If they received the ballots and counted them all and compared them to the official published results, that would be a de facto election challenge. Election challenges, contests, as we've previously discussed in this very courtroom on a number of occasions, are currently time barred by ARS section 16-624 capital D. And a lot of people are unhappy with the short time limitation put by that statute on the ability to mount an election challenge. But that unhappiness is not anything that you have the power to do anything about. If the political parties or anyone else, Joe Public, is unhappy with the short period of time allowed by Title 16 for an election challenge, they need to drive up to Phoenix and take it up with the Arizona State Legislature and get that law changed. And Pima County isn't saying that should or should not happen, because that really isn't an issue here. But we must be honest to the law, and the law prohibits an election challenge at this late date and provides that this court doesn't have subject matter jurisdiction to entertain such a challenge. Number two, if this isn't an election challenge, and the complaint, Second Amendment complaint is kind of hard to read about what they're actually trying to do. What it is their request that this court facilitate them conducting a criminal investigation. They want to get the ballots to assist them in determining whether or not a criminal offense, as defined by Title 16, occurred. So in order to do that, they have to have, this court has to have jurisdiction to assist them in that task. And the statutes that they cite, the Arizona constitutional provisions that they cite, don't provide that jurisdiction. The political parties are not given the power to investigate and then prosecute crimes. That's uniquely bestowed upon the state of Arizona and its political subdivisions by the Arizona Constitution at Article 6, Section 25. When I say it's difficult to tell, that is because the amended counterclaim skips that part of a pleading where we would normally see a cause of action defined. The jurisdictional basis, which is really just general jurisdictional powers given to the court, is cited, fact allegations are made, and then they move directly from the fact allegations to the relief that they want from the court without telling us, you know, I'm pursuing this specific type of cause of action. Your Honor, you're going to hear, I'm confident, some passionate pleas about how if they don't do it, nobody will, and this must be done to protect the public's interest, and other such matters. But in fact, as the court has already been advised, the Attorney General's office has been involved in looking to whether the contentions of ballot tampering are true or not. And the bottom line here is that the Democratic Party and the Libertarian Party are unhappy with either the pace or the steps or the results coming out of the Attorney General's office. And I'm not saying that they're not entitled to be unhappy, but that doesn't mean that they get to come to you and say, I think the Attorney General's office isn't doing it good enough, and we can do it better. So Judge, we want you to help us be the ones to do this criminal investigation. And I'll just move down the road to what an extension of that argument means. Let's say that I believe somebody on my street is dealing drugs out of their house. And I go to the county attorney's office and I report that. And I ask them to put their special investigators on it because I haven't had any results from the police office. And the county attorney's office says, well, we'll take a look at it, but nothing happens very fast, and I'm still unhappy. The house is quiet, it's not a nuisance, but I just know that that's happening down there, and I'm unhappy with how the county attorney's office is progressing or not progressing. So, am I able to disregard Article 6 of the Arizona Constitution at Section 25 and file a civil cause of action and come in here and ask you to issue a warrant allowing me to enter this home down the street to find some evidence of illegal conduct and then come back to you with that evidence. We'll just leave the police and the county attorney's office out of there. Come back to you, put some evidence on for you, and then you'll enter a finding that, yeah, criminal conduct is occurring there, and then working together, you and I will fashion a remedy for this criminal conduct. I know it's somewhat of a ridiculous example, but that is the logical extension of what they appear to be arguing. Despite the passion with which the Democratic Party and the Libertarian Party argue their case in writing, and I'm sure we're going to hear lots more today, things that aren't in writing yet, for the most part, the issues that they want to pursue are either moot, and that's an election challenge. It's way past time for an election challenge, so that issue would be moot, or to the extent that they're looking to the future, are abstract or advisory, which this court also is not required to assist them in obtaining. Even if you accept all of the well-pled allegations of their second amended cross-claim as true, there is not a competent allegation that they have a good faith basis for believing that any problems that occurred in the past are expected to occur in the future. As such, what they are really looking for is an abstract or advisory ruling to the extent that they say, no. As such, what they are really looking for is an abstract or advisory ruling to the extent that they say, no, this isn't about the past, this is about what will happen in the future. I don't want to get today into a discussion of the problems that occurred with the special May 2006 election, because none of that's before the court, other than to say there were some problems. They were identified. The Pima County's Department of Elections believes that they were remedied, and this court doesn't have anything in front of it on the record to show that any problems that occurred then were not remedied and are expected to continue into the future. This is all about the May 2006 special election and the Democratic Party and the Libertarian Party's unhappiness with the results of that election and their unhappiness with how the Attorney General's office is pursuing alleged criminal conduct that they brought to its attention. If in fact this case is about uncovering and then remedying criminal conduct, I would also propose that that's not the province of anybody in this room other than perhaps you, if this Attorney General's office were one of the parties that was involved. And so if that's what we're talking about, then we've got a Rule 19 problem, and the Attorney General's office needs to be here. In closing, I would just want to comment briefly upon the exhibits submitted to the response filed by the Democratic Party and the Libertarian Party. Items 3, 4, and 5 are editorial pages from newspapers that I read and enjoy. And number 6 is an unsigned minute entry ruling out of Maricopa County Superior Court. While interesting, I would propose that those are irrelevant to any considerations you have. Sometimes we agree with the editorials in the paper and sometimes we disagree. Sometimes editorials are intended to stimulate public discussion, which is a valid purpose, but they're not evidence. They're hearsay, they're opinion. I don't think a discussion of them is worthwhile or offers any meaning to what's in front of this court today. And certainly an unsigned minute entry ruling out of a Maricopa County Superior Court case has no precedential value. It's my intent to allow Mr. It's my intent to allow Beth Ford's position in the reply to be argued and only briefly join in that to the extent that Pima County has anything additional to submit in reply, so that we assume the division of labor that we took in connection with the motion to start out with. Thank you.
Mr. Richardson?
I'm not going to add very much. I just want to echo our agreement with what's been presented by Pima County. Again, attempt to take the passions and things out of it and simply look at the law. Because there are two places for the Democratic Libertarian Party to go in this situation if they're uncomfortable. One is to continue their efforts to coordinate with the Arizona Attorney General's office, and number two, the Arizona legislature. Since they've indicated their only concern is that this is an election contest and they want to look to the future. If not, it becomes, I think, kind of an impossible morass for any city judge to decide, how long after the fact. Now we have an election that's over 2 years old. We ought to be delving into who sat at what table and who looked at what piece of paper. Last but not least, of course, we do have one slightly separate interest, independent of Pima County. The Treasurer Beth Ford really does not need to be a party in the cross-claim, counterclaim filed by the Democrats and the Libertarians. We fully support the full dismissal of the motion, but in any event, Beth Ford should not have to be a party to it if for some reason it has any vitality, which we do not believe it has. Thank you.
Thank you. Mr. Risner?
Yeah, thank you, Judge. There is some truth that my clients and I are in fact passionate about honest elections and the democratic process. I think that the way we approach it, though, is that is the role of political parties. Our Constitution, which Your Honor and I suppose all of us have a role in defending and carrying out in Arizona, is quite clear and quite strong in this state. It's really an unusual constitution in many respects, where the power of the people is set forth so plainly, where the Constitution says that the purity of elections is so important. I don't know how many constitutions you'll find in this country that on election day says that citizens can't be arrested on their way to vote except for felonies and breaches of the peace, that you can't even do military service on the day of the election. These are unquestionably important, fundamental matters. And I did, and the Libertarian Party also in our joint filing did go to some length to set out many of the places in our statute that talk about the roles of the political parties concerning an election. And it's beginning to end. It's beginning to end. The parties months beforehand, they get the layout of the ballot. They appoint. They give a list, and the county must appoint the people that political parties say appoint from this list to be the observers at the polls. It is the function of our party and every political party, it should be their function to see that the election process is pure, clean, honest, and to uphold the franchise. That's our duty. That's our obligation to the people of the state. Political parties surely propose policies that they're in favor of in terms of good government and what's in the public interest. But when it comes to elections, we're all tasked, all political parties, with monitoring the purity and monitoring the actions of those elections. You know, I went back to and looked at the history of, you know, our election statutes. I started in, you know, the 1874, 1877 statutes, you know, on through the years. And what initially was done in the state, and in fact the statute still in our books, I think it's 16601 if I remember right. But what happened is when people voted, the polls are closed, the public can be there, anyone that can fit in that room, and they counted the ballots publicly and announced the results publicly. Interestingly enough, although it's a little bit off the mark here, in 1877 there was 40 days to challenge an election. Then 1913 they cut it down to 20, 1928 20, 1939 20, 1955 20, and that 40 days to challenge was at a time when they publicly counted them in the room and everybody saw what the numbers are. Now, this is not an election challenge. We're clear. The Democratic Party, the argument is that I just heard was that the Democratic Party was unhappy with the outcome of that election. The Democratic Party endorsed and urged the public to vote in favor of the RTA. They're not unhappy. My client is not unhappy with the outcome of the election. But if the election did not represent the actual votes of the public, yes, we would not be happy about that. But we're not challenging the outcome of the election. What this motion says is they say that this court has no jurisdiction. And what is of concern to us, because we are tasked with seeing that votes are honestly counted, we are concerned when we have an affidavit that says the election person who ran the computer admitted rigging the election. We are unhappy that there is considerable evidence that corroborates that. But I need not go into that because this is a 12b6 motion. The posture of this motion is not to test whether that may be the case. The posture of this motion assumes that in fact the election was rigged. The posture assumes that the same individuals who operated the computer are there, the same man, everything is the same. That in fact it was important enough to rig one election and they're running another election, and when will it be important enough to rig that election? That is a matter that is of supreme importance to our political party, because that is everything we're about, is having honest elections and an honest count. We're asking for prospective relief. We will not be asking this court to set aside the RTA. It's not in the pleadings, and we're not asking that of this court. The argument that I've heard is that, well, if it turns out that when the ballots are looked at, and again, we're not asking for the ballots to be turned over to the Democratic Party. We're asking for a procedure where the court maintains control and we find out if, in fact, that election was rigged. If so, there's prospective relief that we will ask the court to enter that will protect the franchise in future elections. Now, what I had filed as sort of that thick stuff that you got in court this morning isn't, well, it is important. Arizona statutes, and it's important because it's I think, a key part of the background. Arizona statutes that will give someone 5 days to challenge an election, were such a challenge to be made, is impossible as a practical matter when computers count the votes. We've I attached statements, deposition by Joe Canefield, who says everybody in the country knows that this software is insecure. We've had experts, one appointed by the Republican Party who's on the County Election Commission, Mickey Donahoe, who's retired from the NSA.
Your Honor, I'm going to have to object. This is way beyond anything in the record.
Well, it probably is, and we're really looking on the legal aspect of this, but I'll give you some leeway with respect to that. I think he's explaining to me what those documents were that you provided today. Are you not?
Sure, and incidentally, since Ms. Fickbaum supports Pima County, I put in our original filing the determination by Judge Miller that the software is insecure. And it was the argument. She's prohibited by res judicata and collateral estoppel from suggesting that, or arguing that the software that we use in Pima County is somehow secure. It is insecure. It is, there's no question, and Pima County argued this thing, there's no question that it's easy to rig an election using a computer, extremely difficult to determine, and virtually impossible with any competence to know that within a 5-day period of time.
But as you said, all of these facts that are in the complaint are under the rule. I've got to take them as true, right, for the purposes of this argument. Right. So it really isn't necessary to rehash the facts. What I think is, what I'm concerned about, and I think what you're all concerned about is do I have a legal basis in which to, in essence, take control, or stated another way, jurisdiction over this matter and the other issues, the other legal issues that have been raised. Sure.
But in looking at that jurisdiction, it is a point that there is no way that anyone could ever challenge an election where a computer's used. That's a point that has relevance. Yeah, right. So,
and let me ask you this,
yeah.
As Ms. Fickbaum points out, why is that not an issue that the legislature should address? She says that everybody's unhappy about this 5-day limit. It should be extended. Apparently, unless your research indicated that it was, like you say, 40 days when they did hand counts and there were probably a few thousand votes at most. Why shouldn't the legislature take up that issue and say maybe we need 40 days?
Well, Judge, I can give you a long list of what the legislature should look at. The legislature has...
But I mean, as opposed to the court, the legislature has said, we got 5 days.
Yeah,
And we may all disagree with that,
yeah.
but can we just ignore it?
No, Judge, this isn't an election challenge. They said you have 5 days for an election challenge. I accept that. So, I think the argument is we're saying as political parties, we've got a prospective problem in the future that this court can address. That's what this is about. They're saying, hey, wait, but if we address the problem perspective in the future, then the public will learn that the election was rigged, and they'll be disturbed, and somehow that'll be against the public interest, and that will necessarily create some sort of problem for this other thing.
Let me make sure I understand what you're saying. What you're saying is that we should go into the ballot, we should look at them, we should determine whether or not the election was, I think in words you've used, rigged or not rigged.
Yeah.
If it was rigged, we ignore the fact that it was rigged, except we tell people don't rig it again in the future.
No.
Your client's shaking his head yes, and you're shaking your head no.
Well,
That's the problem when you have lawyers.
That's what the problem when you have clients, period, isn't it?
Judge, we will offer prospective relief that we can be assured they won't do it again. We're not going to ask you to tell them not to do it again. We will specifically show what you can simply order to make sure that they can't do it again.
But you're asking in the first instance for a finding by the court that the first election was rigged. And we're just going to ignore that. You're basically finding that it's an invalid election, but we're going to ignore that except to have some prospective relief.
Well, whether you, I don't think that, we're not filing a challenge to that election. This court could certainly determine, look, the votes weren't accurately reported last time, but there's a statute that says you can't challenge it, and then the legislature can change that statute. I'm not suggesting that you don't have to follow that statute, or that you don't have to follow all the cases that say you're required to follow that statute. But are something as important as elections, if we know that the election was rigged, is this court required to say there's nothing that can be done on behalf of the public? We have to let the same people run the next election with the same computer with no one checking?
Well, what if in fact you did bring an election challenge on the 7th day, and we all know that it was rigged? We all know that it was rigged.
Yeah.
You have indicated that you don't have any quarrel with that. But if you were to bring an election challenge on the 7th day, our courts have said it's too late. We would have known it was rigged, and we have to sit there and ignore it. What's the difference between the two? What's
the difference? The difference is there's an election every year or two where the next election can be rigged. It's the next election that we're concerned about. And we don't believe the court is powerless to sit in the chair and say they can go on keeping rigging elections, even though it's impossible for anyone to ever find out and make a challenge in time, and even though the Democratic Party can do everything that they're required to do. They can get hundreds of people, as we do, have hundreds of people that go in, 410 precincts in Pima County. We have people that watch every step. They photograph what's going on. But if the election's rigged, there's nothing anybody can do. There's prospective relief that this court can give.
So in the first instance, because it's an election challenge, I can't even hear the case. You would agree with that?
Yeah, I agree that you can't hear an election challenge. That's right. But we're not here for an election challenge. What we say is that you have equity jurisdiction to give us prospective relief for the next election and the election after that. And the reason that I'm mentioning the remedies that the legislature has is that there are no remedies there. There are none.
Let's talk about the public policy of the city of Arizona, which I think both of you have referred to in your briefs. There's a balance, obviously, that we all have to make. And the courts have said, at some point we have to have finality in our elections. Right. And it doesn't take a lawyer or a rocket scientist or a brain surgeon to understand why. At some point, we're not going to be able to go back to an election and disrupt that for a variety of reasons, which the courts lay some of those out. At what point do courts on equitable bases stop going back to elections, recounting, trying to determine whether or not they were conducted properly? I mean, for example, should we go back, maybe it's a little late, but should we go back to the presidential election of 2000 and see whether or not that was done properly?
Well, a couple things. First of all,
I know you'd like to, being on the Democratic Party.
Well, we are, in fact, aware of numerous electoral issues nationwide that are of concern to us. But the...
and it's good that you are, and this is a good thing to listen to. I agree with you. Policy and finality, when do we stop?
Well, the legislature has said, and they've passed a statute in this state of when you can go back and challenge an election. But the problem we have is that our votes are counted by computers. The computer's easy to rig. The same person sitting there who may have rigged the last election and can rig the next one and the next one and the next one after that.
You know, the court has faced, and it's a very concerning argument. The court is faced with this argument in elections and breathalyzers. You've seen that in the press lately. I add that only as an editorial comment.
Okay, but I don't know, you know, people in breathalyzer, I don't know what those fact patterns are. Our fact pattern here takes as a matter of fact that the RTA was rigged. That's our fact pattern.
Exactly.
Our fact pattern is they rigged it using a computer.
Absolutely.
Okay. That's an important matter. And it couldn't be dealing with anything more important than our democracy.
I agree with you entirely.
Okay. So the issue simply is, if it is a fact that using a computer with lousy security, a crook's running it and is rigging elections, does the court have the ability to give prospective relief? We say the answer is yes.
And it is under the court's equitable jurisdiction that
Yes.
gives you the legal basis.
Yes, it is. And I don't think it's a complete answer to say, well, gee, you know, what if the public knew, you know, and that there was nothing that could be done about it? We can't let them know. But we must, for the next election, prevent it from happening. That is in the public interest. People, when there are decisions made on policies or when people are elected, we must know that that was based on a majority vote that was accurately and honestly counted. You look at the Arizona Constitution, that's why I listed all of it. It is rock bottom. It is solid. And I don't think that you say, yep, it was rigged election, it was illegal, and we have to, just because there's an attorney general that could do something about it. That's his job. Our political party's concerned about the next election. And it doesn't help to look at an individual and say, well, we've got this attorney general that might do something. What if it was Attorney General Blagojevich that was in charge? And he had some deal working or somebody, you know, whether there's a criminal prosecution or what he does, our attorney general, he or she, they have discretion. This court cannot enter an order telling the attorney general what to do, and we sure can't. But the court can enter prospective relief to absolutely prevent this from happening in the future, and you've got jurisdiction to do that. You're obligated to do that. It's your oath, it's your job, it's what courts are here for. You just can't wash your hands and say, yep.
No, sir, do not please say that I'm washing my hands of this matter.
No.
That is an insult to this court.
I wasn't.
Please do not make that as an issue here. This court is taking this case extremely seriously. I have read everything that you have submitted to me, and I am allowing you an absolutely level playing field, 100%, and I will follow the law. I have strong shoulders.
Good, Judge. I didn't do it. What I was saying was, by you, I'm saying the court system cannot do that. That's what I'm
The court
talking
system
about.
will not do that. We will not wash our hands of this matter. We will take this absolutely 100% seriously. I agree with this 100%, the necessity for integrity in this system, and as you have indicated, I have sworn to uphold the Constitution, and I take that oath absolutely 100% to heart. Please do not, the court system will not wash its hands of this matter. Okay?
Yeah, thank you. You know, just looking at the notes from Ms. Fickbaum's argument, and I think she argued that there's no, we didn't allege a good faith basis that what happened in the past will occur in the future. And we don't know that they will rig an election in the future. But it is our obligation as political parties to do what we can to see that they will not do it in the future. And we certainly will be able to offer prospective relief that will see that that cannot occur, Judge. Thank you.
Assuming we get to the point of Rule 19, having not joined the Attorney General, what's your position on that?
Our position is that there's, it's my understanding that you can't order Attorney General to investigate, to prosecute, or do anything. I think, you know, it's the executive branch. He's got his job. He does what he can do. He has an open investigation. What's occurring, I have no idea. He won't communicate with us. He won't accept information with us. I don't know what's going on, but he could, I'm sure, petition. I mean, the Attorney General can do what the Attorney General wants to do, but it's not something that this court can order him to do, and therefore he's not required to be here. He doesn't have possession of the ballots. The ballots are in the possession and control of Beth Ford.
So it's your understanding that if the Attorney General were to be brought in, about the only thing he'd be brought in for would be for the court to say, okay, you've got to look into this, basically. And that there's no sense doing that because we can't do it.
Right. Right. Yeah. Thank you.
Everybody wants elections to have integrity. Everybody in the room wants to have integrity. But it goes too far to have a situation where almost 2 years after an election is held, because that's when the cross-claim is originally filed by the Libertarian Party, you bring an action saying, I want to delve into the details of that case, because there's no other way to do what they want to do, and I think they admit this. But then to look at the ballots and to review the minutia of that election in circumstances that are long and complicated and may take, as their expert says, a year of forensic analysis to determine whether that election was or was not properly conducted on the suggestion that, well, we know we've missed the timeline, and therefore we want to just find that information out so we can come back and ask the court to do something else for the future. That's going too far because that has no cutoff.
Assuming we have a rigged election,
Yes,
and I have to assume that for purposes of this.
I understand that.
Why should we not get to the bottom of it?
Why we should not get to the bottom of it is that despite everyone's intentions and desire to have election integrity, we know that it will have major consequences anytime you do things. First of all, just the consequence of the litigation, the cost expense of the litigation. Number two, let's assume it is rigged. And let's assume what everybody has said, there's nothing you can do about it. You're going to have a sitting political body that this a determination that you're going to not let somebody run some machine in the future is going to be very minor compared to the impact that the untold story, the story that would be out there, but then you'd say, but I can't upset the election. That is why there is a finality of the deadline. No one likes the 5 days. And it's fine to suggest that the legislature should change the 5 days and make a reasonable timeline. But there has to be some timeline.
But Mr. Risner is saying this is not an election challenge, that the 5 days does not apply, and that this is, in fact, an equitable action for prospective relief.
Mr. Risner also says that neither party is in the same pleading where he says it's not an election contest. He says neither party is in favor of the passage of any measure or the seating of any candidate that does not receive the majority of plurality of votes cast. In the same pleading, he also says that he notes the importance of the public in determining whether the RTA election results are fraudulent. We can't do one without in effect impacting the other. If this was a case where there was a concern about what someone was doing, and you could look at that someone and track down what they were doing and say whether you get to do that or, that might be a different situation. But when you have to look at an almost 2-year-old election in a manner that for him to be able to be entitled to any relief, in effect, pretty much destroys a sitting public body, that's inappropriate, and there's really no place for it in the law. There isn't such thing as, what kind of things is he going to ask you to do if he found it rigged? We've conveniently missed that. One of the things I would ask the court to do is, we were all delivered the packet of materials, the Democratic Party supplemental memorandum declaration of exhibit, has, I think, a very telling affidavit, is the final affidavit in it, an affidavit of a Michael Donahoe, and he talks about that the software is able to be manipulated, that they've gone back to the legislature and done some helpful things because they had this manual recount thing, but that wasn't done, that was after the 2006. And he says, really, to look at something like you had in 2006 is going to take a year of forensic analysis. And then he says, and so if we do that and find out what could we do for the future, well, we could sort early ballots by precincts and do different types of hand count audits. We could photograph the ballots and post them on the World Wide Web. We could require frequent backup of the databases. so that we can forensically analyze those in a different manner. Is that this case? Are we in a case right now where we're going to be setting, there's no more jurisdiction for the court to develop those type of election processes and procedures than there is to determine, whether the RTA ballot was rigged. There's even if you think, well, okay, I'm only looking to the future, there's nowhere to go. It is just inappropriate under these circumstances to do something that would have such a dramatic effect. That, as we have said, originally, the remedies in the legislature, the remedies at the Attorney General's office. Because if not, even if the legislature changes the timeline to 6 months, somebody 8 months from now, because there's always a conversation or something that brings this out. Here we have an affidavit of somebody talking in some bar to somebody else and saying something. Well, that could have happened after 4 days, or it could have happened after 4 months. Right? After 4 days, they could have run down and filed an election contest. Obviously, after 4 months, they can't. But after 4 months, can they file one of these? If it happens after 8 months, can they file one of these? If it happens after 24 months, after 48 months, no. The statutory scheme is clear. And there simply is no jurisdiction to thoroughly analyze and go into ballots that are supposed to remain sealed by law, until they're destroyed, and review those on an idea that maybe I'll start changing some of the processes for future elections in the ways that they suggested. Maybe I'll have them put on the web. Maybe I'll tell the different precincts to sort them in a different manner. Even those suggestions are legislative matters. They're not judicial matters. So for the reasons that I think were argued in the original motion, is this case cannot go forward, the cross-claim, only the declaratory judgment action. Thank you.
Mr. McDonald, same question.
Want to restate them?
Remind me what the question is.
Well, for example, one of the questions is why should we not permit an inquiry into this election to determine what problems were occurred, if any? And secondly, Mr. Risner's position is that this court should exercise its equitable jurisdiction, given that this is not an election challenge, and should look at this as not an election challenge, but rather exercising its equitable jurisdiction to provide prospective relief.
Okay. Can I take the second one first?
Of course.
First of all, I'm not going to re-argue what Mr. Richardson just argued. I think that you can look at that waste can and say, that's not a waste can, but it still is. And just because Mr. Risner says it's not an election challenge doesn't mean it's not. You have to look at what the outcome of what he's asking for would be. Just like you've got to look and say, well, Mr. Risner, you're saying that's not a waste can, but I'm looking at it, and it sure looks like a waste can to me. And with regard to the prospective relief part, I would like to correct a couple misstatements of the record that were made to you. The answer in second amended cross-claim is what it is. They amended it twice. So let's assume they got it right and it's where they want it to be. I was just reading it again while Mr. Risner was arguing, because he was saying a lot of things that I didn't remember seeing in the record. And I'd like to correct those right now. This does incorporate an affidavit in paragraph 11 of a former county employee who was fired, who alleged that he talked to an elections employee who said, I rigged the election. And the answer in second amended complaint incorporates that. What Mr. Risner doesn't tell you is the accused employee has stated under oath that he denies rigging the election, and he denies ever talking to the person who said that he said what he said, and he denies ever being in the place that he supposedly was when he made these admissions. And even the Democratic Party and the Libertarian Party, in making their answer in Second Amendment counterclaim or cross-claim, don't say that this election was rigged. You do not have to accept that fact as a well-pled allegation for purposes of this motion. What they allege is that there is substantial evidence of tampering. And then they allege that the court should get the ballots and make them available to them to examine. So Mr. Risner said, well, we don't want the ballots. That's not true. They do want the ballots because they want to examine them, and that's paragraph 12. And then in paragraph 13, they say, this court, after providing the parties with adequate time for discovery, should conduct a hearing to determine if the ballots were tampered with. So in submitting their pleading, the Libertarian Party and the Democratic Party were intellectually honest, and they said, we don't know. We have an allegation. I think implicit they recognize that those allegations have been denied. They want to look at the ballots to find out whether or not it's true. They did not avow to the court that there is a good faith basis for believing, yes, in fact, the election was rigged. They say, we want to look at the ballots and figure it out, and then we want to have you help us remedy it. So all this argument about how we must proceed forward based upon the assumption that the election was rigged is just wrong. And that's not what they said in their pleading. And Mr. Risner has talked about a lot of things that aren't in the record and aren't part of the complaint that was filed. So your question about the equitable jurisdiction, it isn't. I believe it is an election challenge. And number two, I don't think that when you look at their complaint, you will see enough pleading enough pleading of material facts to demonstrate that there is a present and clear risk of a problem with a future election. And I got to tell you, what's been implied to you today here, which again, I'm at something of a disadvantage of, which is why I have Mr. Moffat with me, because this stuff isn't in the record, wasn't in the response, and maybe it wasn't something that got delivered to my office yesterday, which I've yet to see, by the way. Pima County has made hundreds of procedural and control changes to the election process since the May 2006 elections, most in cooperation with the political parties. So to stand here today and imply to you that everything is the same as it was in May 2006 is just wrong. And if you want to really get into that and talk about it, Mr. Moffat was intimately involved in that process, and he can talk about it. But again, when I started arguing today, I said, can we just stick to the issue that we're here about? And that's the issue about when you look at the Second Amended cross-claim and accept its well-pleaded allegations as true, is there an actionable claim here? For the court to exercise this inherent equitable relief, it shouldn't be in a simply advisory or moot capacity. That does not serve anybody's interests. For the court to make a ruling about something bad happened years ago without that having the possibility of fixing something that there's a pretty good evidence that is going to happen again quick if you don't jump in. Judge, if you don't make this ruling, they're going to bring the bulldozer over and take my tree down. If you don't tell them that that tree's on my property and not theirs. I mean, that's the kind of stuff that we do prospective relief for. This is all about the desire of a couple of political parties to again criticize what happened in connection with the 2006 elections in May. And nobody's going to stand here and tell you that those elections were perfect. What I am going to stand here and tell you is that Pima County has made hundreds of procedural and control changes with this electoral process since then. And I really think that that addresses everything above and beyond what Mr. Richardson already argued, except for the one other thing I would add is this if we're concerned about the procedures for retaining election materials, how long they should be retained, who should have access to them, who should be able to use them, it's not just the legislature that we need to be talking to. Certainly some of those procedures are set forward in Title 16, but the Secretary of the State has published a whole manual about election procedures that has the force and effect of law. And certainly if somebody's in front of you asking you to put new procedures into place prospectively, you know, that's also the province of the Secretary of State.
Thank you. I'll take the matters under advisement. Mr. Greco, if you've got a motion that you want to be heard, why don't we have all of you come back and we'll get a date set for that motion. And so if you all come back, I'm glad that you
Your Honor, I apologize for being late to the court, counsel, and the parties. Judge Collins kept me longer than I thought he would.
And we understood that you were in a predicament. We did wait for a little while, but we had to go ahead and start without you. And your client, I know you had filed a joint motion with Mr. Risner. Mr. Risner and your client agreed to go ahead and have Mr. Risner argue your position. So, but thank you for stating that.
Thank you.
And you are forgiven. Okay. Come on back if you would, please.
We stood in lines outside 3 hours, maybe 4. A rainy November 2nd, 2004. All across our nation, too many to ignore. We turned out in numbers they'd never seen before. I should know, dear, I've been voting here since the Second World War. My name is Amos Connolly. Now they're telling me my vote don't matter anymore. They took my name, they purged it from the roll. What they gained cannot compare with what they stole. This is my democracy. Don't you go telling me my vote don't matter anymore, and is not worth fighting for. The fix was in, that's all she wrote. They did not win. Our hearts, our minds, our vote. What is known, and the evidence is clear. I'm not alone. There are thousands of us here. This is my democracy. You won't go telling me my vote don't matter anymore, and is not worth fighting for. This is our democracy. We'll fight to keep